You're at home, relaxing, maybe watching TV, maybe you're asleep, when suddenly, bang, 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 police, we have a warrant. Open the door. Your stomach drops. Do the cops have to show it to you? Can they come in without it? What can you say without making it worse? Let's be clear. Having a warrant does not give cops unlimited power. And what you say next will absolutely decide whether your rights get protected or run over. I'm Jeff Hampton, the People's Lawyer, and in this video, I'm going to show you, number one, what a real warrant is supposed to look like. Number two, how cops use and abuse the system to basically create loopholes around the warrant. And number three, the exact words you can use when cops show up claiming we've got a warrant. We'll break down the law, the loopholes, and the real cases where people's homes were destroyed because they didn't know what to say. But we have to start at the root. What a legal warrant should be and how it's supposed to be designed to protect you. The Fourth Amendment to the United States Constitution is supposed to be our shield, our protection against unreasonable government intrusion. In fact, it says, and I quote, "The right of the people to be secure against unreasonable searches, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Let's break that down. A real legal warrant requires three things. Number one, probable cause. The police must have real facts, something that establishes some crime may be taking place, not just a hunch. The Constitution says that police are supposed to have enough evidence to be able to convince a neutral judge that there's enough here to actually warrant a search. Number two, particularity. That means cops can't just show up with a warrant and search the whole house. They must specify the exact place and exactly what they're looking for. Maybe it's a weapon, maybe it's a laptop, maybe a named person. And then number three, oath or affirmation. Whoever provides the information to get the warrant must swear that it's true under penalty of perjury. Now, why is all of this such a big deal? Why did our Constitution make it this way? Because back in colonial times, the British used to get what were called general warrants. No names, no limits, just an excuse to raid, loot, and intimidate. The founders hated this. In fact, this was one of the main reasons for the American Revolution. So when they wrote the Fourth Amendment, they didn't want just a permission slip system. They wanted accountability. The warrant system is supposed to be a guardrail to create that accountability and not just be a green light. So why does this warrant guardrail that the founders created in the Fourth Amendment, why does it seem to fail so much? So a warrant is supposed to be your constitutional shield. Probable cause, sworn facts, judicial approval, accountability. But here's what actually happens in the real world. Corners get cut, oaths, they get faked, and judges rubber stamp warrants without even reading them. And then what happens? The innocent end up in handcuffs. Their homes are destroyed. They end up in jail for things they didn't do, all because the system failed. Let's talk about how it all happens and how fast it can take place. Take the case of Michael Mendenhall, arrested over hearsay. Michael is a business owner in Denver. One night in 2023, he trespassed another person off of his property. That trespasser then makes a wild claim to the police. He calls the cops and claims that Michael threatened him with a bat. The cop on scene doesn't verify it. Instead, and by the way, I see this happen all the time, he passes the story over to a detective. The detective never talks to the witness and never checks the footage. He just writes it down for the warrant and then swears to it in the affidavit and takes it to a judge. And boom, a judge is now signing a warrant based on third-hand hearsay. Police then raid Michael's home. They seize a bat they find within the home and then they arrest him. The charge, felony menacing. The real story? The bat they seized was actually a commemorative item that he had collected. The threat was the actual trespasser being told to leave. Charges were then dropped within 72 hours. But by then, Michael had to spend a night in jail. His name had been dragged through court records. He lost access to his property for a short time, and there was no recourse for the damage caused by the raid. You say, Jeff, why does this matter? This warrant was approved with no first-hand evidence, just a broken game of telephone. The judge didn't ask a single question. The detective didn't even interview the accuser. And the cops didn't even think about looking at the security footage. They just rubber stamped all of it. And the officer who swore to the entire affidavit wasn't even a witness to it. It was third-hand knowledge. Now, remember when I said earlier that a requirement for a warrant is that the Fourth Amendment requires that the warrant must be supported by an oath or affirmation. That used to mean first-hand testimony under penalty of perjury. But in 1960, the Supreme Court weakened that standard in the case of Jones versus United States. The Supreme Court ruled that hearsay, which is things someone else said, could now be used to get a warrant, as long as the officer believed it. That decision opened the floodgates. Now cops can say, well, somebody told me this guy did something, and I think I believe him. Now it's sworn to, judge approved, and now you get raided. But it gets worse. Sometimes it's not just hearsay, it's straight up lies. Lies that get innocent people SWAT raided in the middle of the night. Let me show you exactly what that looks like. April 2024. Rural North Carolina. A couple, Avery Marshall and Alyssa Carr, are asleep in bed. A SWAT team out of nowhere smashes through their door at 1 a.m. Immediately, they throw in flash grenades and start pointing rifles at their kids. Why? Police were tracking a phone they believed belonged to a car theft suspect. The phone pinged within about 52 meters, which is half the distance of a football field. Now think about this. This could have been anywhere within the distance of about 6 homes in that area. But the officers applying for the warrant from the judge, they didn't tell the judge that at all. Instead, they said, we think this suspect is at this address. The cops also made baseless claims that these poor people's vehicle matched the vehicle of the suspect. Think about this. The cops withheld key facts. They lied about the specifics on the car, and they made it sound like this was the only address where this particular suspect could be found. And the judge didn't ask any questions and signed off. No backup, no cross-check, just your regular everyday paperwork. The result? The doors were blown off. A family was forever traumatized. A house is damaged, and no suspect was actually found because the cops were sloppy and they lied on the warrant. This wasn't just a bad guess by the cops, it was a bad warrant. And now the family had no choice but to sue to get their repairs done and to receive justice. So we've seen warrants based on hearsay, and we've seen warrants based on lies. But what happens when the warrant is real, but the reason for it is actually personal? What if the police are using a warrant to silence their critics? So far, we've looked into lazy, sloppy, or dishonest warrant requests lead to people being raided and wrongfully accused. But sometimes it's not about sloppiness. It's actually all about revenge. Because when a public official decides they want to punish their critics, they don't need a gun. All they need is a judge's signature. This brings us to Marion, Kansas, 2023. It starts with a local newspaper, the Marion County Record. They published a story critical of the mayor and the local police chief. In fact, they exposed how a friend of both of them had actually lied on a liquor license application. Days later, the police chief magically shows up with a search warrant. The police chief then raids the Marion County Record's office, and they raid the personal home of the 98-year-old co-owner of the newspaper. And to top it all off, they also decided to raid the home of a city councilwoman who had helped expose the entire scandal. They took every phone, every computer, and they took all the notes. And all of it under the guise that they were investigating an identity theft. But here's what they didn't tell the judge when getting the warrant. Number 1, the so-called stolen information was publicly available. Number 2, the reporters never actually hacked or broke into anything, and the cops knew it. And number 3, the alleged victim had a personal connection to the mayor. The truth? The warrant wasn't about investigating a crime, it was all about payback. And the tragedy of it all, one day after the raid, the 98-year-old co-owner of the newspaper, Joan Mayer, died because of the stress and trauma of it all. In fact, her family came out publicly and said it very plainly that the city actually killed her with this raid. But think about this. This wasn't a drug case. It wasn't a violent suspect. It was the First Amendment being attacked by cops with an agenda. And if it can happen to a newspaper, it can happen to you. If someone in power decides that you're a problem. Unfortunately, that was not an isolated case. This brings us to Alabama 2023. In Atmore, Alabama, the school board voted not to renew the superintendent's contract. The local district attorney and sheriff who supported the superintendent, they were furious. So what did they do? They accused 4 of their opponents, 2 school board members, a school employee, and a journalist of, quote, leaking grand jury secrets. Except there was actually no grand jury. They just made it up. They told a judge that they leaked secret subpoenas, except there was no grand jury. They literally made it up. But the document, it wasn't secret, and there were no active proceedings to actually protect. Still, The judge didn't even really look into it and went ahead and signed the warrants. The 4 were then arrested, strip searched, and booked into jail. The charges, of course, later they were dropped because it was ruled unconstitutional, but not before they were arrested. Their reputations dragged through the mud and damage created in the community. So let me pause right here for a second and ask, what's actually happening here? How is this taking place under our Constitution? Well, number one, the warrant process is being abused by bad faith actors, being police. Number two, the judge is then taking one-sided information only from the police, not looking into it, and approving these warrants and signing off on them with a rubber stamp. And then number three, regular people who have never been in trouble before and done nothing wrong now become a target. This is the pattern. Warrant abuse doesn't just come from rogue cops. It comes from a system that stops asking questions and judges that stop doing their jobs. But this brings us to the place now where I want you to know you are not powerless. Because even though the warrant system in the United States is broken, it all depends on what you say next. Because if you use the right words, the exact words to address this situation when cops show up, you can still protect yourself from becoming a victim. So if the cops show up at your front door, banging on the door, claiming they have a warrant, it's important, number one, the primary rule is to say less, and the words that you do say will mean more. Step number one, ask to see the warrant. It's as simple as saying, "Officer, do you have a warrant? If so, I'd like to see it." By saying these exact words, it forces the officers to produce the actual warrant. If they can't produce the warrant to show you they have a valid warrant, don't let them in your home. If they then produce the warrant for you to review, you can now check to see, was it signed? Is it specific? And is it actually legit? If they claim that they have the warrant, but they don't know how to get it to you, you can either ask that they slide it under the door, or if it's not available for that to take place for you, depending on your setup at your home, you can ask them to specifically place it up against the window. You have a right to be able to see that warrant before you let anybody in your home. I've seen this happen so many times, where officers will claim they have a warrant only to get you to open the door. Once you open the door, you find out it was only a knock and talk, and they were never really there with any actual signed valid warrant. If they refuse to produce the warrant, don't open the door. That's just an old-fashioned knock and talk, and now they have no right to enter your home because they have no legal basis. Step number two, state specifically that you do not consent to a search. Even if the officer produces the warrant and you look at it and it appears to be valid, it is very important, and we'll talk about recording and everything else here in a minute, but it's very important that you state specifically, "Officer, I do not consent to the search of anything in my home whatsoever." What if the cops start barging into your home or into your business or wherever you're at and start searching anyway? It's important to mention that you do not consent to any area to be searched that is not specifically stated within the warrant. Otherwise, officers will claim that you impliedly gave consent for them to be able to search other places within your home that wasn't specified within the warrant. Why is this important? Because if it turns out that that warrant was invalid or too broad in terms of its application, your specific statement that you do not consent to a search of any other place in your home makes it clear that you will be able to challenge that particular search in court. In fact, I've seen this happen so many times that people will just assume that now that cops are in your house, it's pretty much a foregone conclusion. They can do whatever they want. And I'll hear cops say, "Yeah, I mean, whose room is this over here? You okay if I go in here for a minute?" And people just say, "Yeah, go ahead. That's fine." And the cops will document that, claiming now you gave them verbal consent by not objecting. So we always tell the officer in any situation where they claim to have a warrant that we do not consent to a search of our place, our person, or our things, but we do not physically resist what's going on. We verbally document everything, and as we'll show here in a minute, we record everything that's taking place so that we can use it against the officers if they're violating our constitutional rights. Which brings me to step number three. If it's safe and the officers are actually talking to you about what they're doing, you can ask clarifying questions to document what they're doing may be wrong. Questions like, what exactly is this warrant for? Or what areas or items are you authorized to search for within this warrant? Use a calm tone. You're not obstructing, you're observing, and you're standing up for your rights. Why? Because warrants have limits. A warrant that allows someone to look for a stolen TV doesn't allow them to dig through your sock drawer. Why? Because a TV can't fit in a sock drawer, but if you're not clear exactly what they're there to search for, cops will search everything. Or maybe the cops aren't clear about what type of warrant they have. If they actually have an arrest warrant doesn't give them the authority to search your entire house. They can only look in areas where the person named in that arrest warrant could be hiding. What if the cops go beyond the scope of the warrant and they start searching everywhere? That's when you can say specifically, I do not consent to a search of this area. It goes beyond the scope of the warrant, and I want to make it clear, I do not consent. You've just drawn a legal boundary. You're making it clear what you're objecting to so that if the officers go beyond the scope of that boundary and that warrant, you can now do something about it and hold them accountable in the courtroom. Which brings me to step number 4. Once you've said the first 3 points we've covered, it's time for you to say, Officer, I exercise my right to remain silent. I demand my lawyer. Now be careful, because this is when cops will ask questions like, do you know why we're here? Whose laptop is this? Have you been in contact with James or John? When's the last time you saw him? I know it will be tempting to want to talk to the officers, to take the initiative to clear your name because you've done nothing wrong. But don't forget, even very innocent answers to questions can be twisted or misinterpreted by the cops to make it seem like you're admitting to something you didn't do. Don't play their game. Silence is never suspicious. It's smart. And more importantly, it is a constitutional right you have, and you don't have to fall for the tricks. And finally, step number 5, you've got to observe and document and record everything. If they're searching, watch where they're going in your home. Note who is exactly present, which officers are there, and where they went in your home. Record the encounter and ask for an inventory of every item they took. And if they went berserk and they tore up your place, take photos of all the damage. And if there were any other witnesses present, make sure you grab their information so that you can use it as part of your suit in the future. You say, okay, Jeff, so these are some of the words that I should say. What exactly should I not do? Number 1, never invite the cops in. They may try to bait you with just talk about the neighborhood or how the weather is, or they just want to come in and answer, hoping you answer a few questions. Don't fall for that trick. Never let them in your house. The moment you invite them through the threshold, it's fair game. Number 2, do not try to justify or explain yourself. By doing this, you're falling for the talk trap, where the officers will now begin to continue to talk and make accusations to make you look guilty. Number 3, be careful getting angry or sarcastic with the cops. They'll use this as a reason to claim your behavior was suspicious, which now they will claim they have probable cause to be able to do something else. Number 4, never sign anything the cop puts in front of you without, number 1, reading it and then making sure you have an attorney review it. Otherwise, you're setting yourself up to get duped by the police. Let's be clear. This isn't about being clever. It's about being strategic. Because if the warrant is real, they're going to come in anyway. But specifically how you handle that moment and the words that you say, which we just covered, can decide, number 1, whether you can challenge it in court. Number 2, whether what they find is actually admissible. And then number 3, whether your rights stand or disappear if you're looking to bring a civil rights lawsuit. So now you know exactly what to say and of course not say in the moment. But what if the damage is already done? What if they raided your house? What if they ransacked the house? Maybe there's not only damage to your property, but maybe they made an accusation that landed you in a police car. Let's talk about how a bad warrant can lead to not only a legal fight, but a potential civil rights lawsuit. The instinct most people have after experiencing a situation with a warrant like this is to do nothing because they feel powerless. After all, you don't want to make things worse and you don't want the cops to come back and do it again. But here's the truth. If you don't act, the system won't fix itself, and you may have a right to hold those officers who mistreated the situation accountable. So here's how to fight back step by step. Number 1, not only should you lawyer up at the scene when the cops show up with their warrant, but you should also actually consult with a lawyer to now move to number 2, challenge the legality of the warrant and fight it after the search. A good lawyer can, number 1, file a motion to suppress any of the evidence obtained from an illegal search. Number 2, a good lawyer could request a Franks hearing to prove that the affidavit from the search warrant was false or misleading. Number 3, a good lawyer can then argue that the search exceeded the warrant scope. And then number 4, potentially sue for a civil rights violation if the search was clearly unlawful. For example, in Franks versus Delaware, the Supreme Court held that if cops lie in a search warrant affidavit, the entire case and everything can be thrown out. Which brings me to step number 3, document everything you can. Do everything you can while it's fresh right after the event. So number 1, write down what happened, what time the cops arrived, what they said, what they searched, and what they took. Number 2, get the names of the officers and their badge numbers so that you can refer to who was present. Number 3, photograph any damage that you see that was done to your home or to any of your property. Number 4, save the inventory list of seized items so that you can reconcile what was actually taken, and some of it may have been illegal. Then we look at saving the warrant copy itself. You can actually get a copy of that warrant, save a copy of it if you had, so that you can refer to it and hand it to your lawyer. And then number 6, back up your phone or your home video camera footage if it captured everything that took place. And one of the smartest things you can ever do is to get a home security system that not only shows what's going on the outside of the home, but you could even have a camera showing what happens throughout the doorway coming into your home so that all of it can be recorded. And then finally, it brings us to our big point number 4, consider filing a civil rights lawsuit. Listen, if your rights were violated, regardless of whether you were charged or not, you may have a case, particularly if number 1, they raided the wrong house. Number 2, they lied to get the warrant. Number 3, the warrant didn't exist or wasn't shown, or maybe you were searched and arrested without probable cause. Or finally, maybe you suffered injury, damage, or loss. Under 42 U.S.C. Section 1983, your lawyer can help you file a civil rights lawsuit. And in fact, the examples I talked about before, like that Kansas newspaper, where the poor co-owner of 98 years old died because of that illegal raid. And I also talked about the Atmore 4, who were a part of that school, the actual school board, who were wrongfully charged in that situation. That's exactly how they fought back so that they could hold those local cops who were actually being manipulative through warrants. They held them accountable for their actions. And let me be clear, it's not just about the money, it's about setting a precedent to stop this type of corruption so that it doesn't happen again. And hopefully, what really needs to happen here is these cops are then charged criminally, not just civilly, for their behavior so that it will set a precedent for these things not to happen in the future. And finally, number 5, when all else fails, it's time to know when to go public. If you remember the Marion County Record, that Kansas newspaper we talked about earlier, that whole situation was finally made right, not because of what the courts did. They were going to actually let them get away with a lot of this, but it was because it was strategically decided when it should be released to the news, and public record, public accountability, the call for action here made the difference. If you remember nothing else about this video, remember the 4 phrases that could protect your rights and save your home. Number 1, I want to see the warrant. Number 2, I do not consent to a search. Number 3, I exercise my right to remain silent. And number 4, I demand my right to a lawyer. You don't have to be a lawyer. You don't have to memorize court cases. Just know your rights and use these words. Now, we just covered the exact words you should use when cops claim they have a warrant. But what if instead of claiming they have a warrant, they show up at your front door and now they're just trying to pull an old-fashioned knock and talk and trick you to open the door and have a conversation with them? Well, check out this next video where I break down the 5 tips to stop cops when they come knocking. See you over there.